Good morning. Today I am going to discuss about how to get over to file divorce petition even before completion of 1 year. And that apart, the judgment which I am going to refer discuss about a lot of wordings: exceptional depravity, exceptional hardship. Then they say matrimonial misconduct, cohabitation and consummation of marriage. Then they have discussed about provisions of 13B, 14 of the Hindu Marriage Act. Here, what had happened after the marriage, there was no sexual relationship between the petitioners, respondent and petitioners. Now, since it is 13B, they seems to have filed an application under 14.1 to get exception to file application before 1 year. For that, the division bench of Delhi High Court, AR 2022, Delhi 96, Rishu Agrawal versus Mohit Goyal, deeply discussed about various provisions and uphold the dismissal of family court, granting 14.1, that means the exception to file divorce petition period to 1 year. This is what had happened. So I will read this. You have to go through the judgment if you are really interested to know how this division bench of Delhi High Court discuss about the concept of existence of marriage. There is a prohibition of a dissolution of marriage period to 1 year. What was the intention of the legislation? They also discussed about the law commission's recommendations to introduce these sections, etc., etc. They say denial of cohabitation in marriage cannot be regarded as exceptional hardship or exceptional depravity. That they have discussed. Then they again say mere denial of sex by one or both to other cannot be described as an act of exceptional depravity, though it may tantamount matrimonial misconduct. That's what they say. The terms cohabitation and consummation are different, inherently different, and must not be treated as the same. They have discussed the dictionary wordings about all these things. Then they say the word hardship may simply mean severe suffering or unpleasantness. Hardship by prefixing same with the word exceptional. Denial of sex by one spouse to other by each constitute hardship, but it cannot be exceptional hardship. That's what they say. Then they discussed various aspects about Supreme Court in granting divorce by waiving 6-month period has been referred for the favor of appeal, but that this division bench not accepted that because Supreme Court did not discuss about 14.1. I mean, they have only discussed about waiving of 6-month cooling period. They say, see, the suggestion before this commission, that means the change, Section 13 of the Hindu Marriage Act, amendment, that the marriage has not been consummated owing to the willful refusal of respondent to consummate. If of course willful refusal cannot, a settled and definite decision come to without just excuse. That was say. Then they say all these things I have already discussed. Then they say 13B conditions. Number 1, first the parties have been living separately for a period of 1 year and more. Then they have not been able to live together. Thirdly, they are mutually agreed that marriage should be dissolved. Then here, appellant sought the waiver of period by resorting to provision 14 that 14 read as follows. Notwithstanding anything contained in this act, it shall not be competent for any court to entertain any petition for dissolution of marriage by a degree of divorce, unless the date of present of the petition 1 year has lapsed since the date of marriage. See, normally I used to totally deny to file application and inform the client that they are not entitled at all, as the wordings are there. But however, an advocate seems to have filed an application to waive that period. They say then the 14 they have discussed it. Then they say the provision to section 14 provides for circumstances wherein upper said condition can be relaxed if it is proved that there is exceptional hardship on the petitioner, or second, there is exceptional depravity on the part of the respondent. These two grounds are there. Then they say, however, the prescription of statutory minimum period of separation of 1 year in section 13B1 on one hand, and the waiver clause in the provisions section 14(1) the other hand, need deeper consideration. That's how they have said it. They referred what is difference. Consummation according to Cambridge Dictionary means the act of making a marriage or romantic relationship complete by having sex. That is consummation. Cohabitation according to Merriam-Webster Dictionary, to live together as or as if married couple. Then they say conjugal according to Cambridge Dictionary, connected with marriage or relationship between two married people, especially their sexual relationship. So sexual relationship is an integral but not the beginning and end of cohabitation. That's what they say. Then they discussed about depravity. Then they also discussed exceptional, very unusual. Depravity, the state of being morally bad. Hardship, a situation that is difficult and unpleasant because you do not have enough money, food, clothes. This is what they discussed about other dictionary words also. Finally, they hold good about the family court judgment rejecting to entertain. However, they say we reserve the right of parties to move appropriate court independently after expiry of 1 year of separation. They specifically, in the light of discussion above, we are of view that though the denial of conjugal relationship is a good ground for divorce and tantamounts to cruelty, but the same cannot be said to be exceptional hardship. The exception of exceptional hardship or exceptional depravity would be attracted in extenuating circumstances and is not intended to mean or be treated on the same line as cruelty simpliciter. Therefore, by discussing the very purpose to make them wait for 1 year, that is for they say, see, the Hindu Marriage Act serves two twin purposes: codifying the rights and obligations of individuals governed by the said act in relation to their and advancing the social purpose to protect the institution of marriage. This is what they say. So it will be far better if you want to write about project report or other theses, whatever may be, while doing PG courses and particularly in excellence law courses. This may help you go through the judgment. But so far, practicing advocates are concerned, they must understand that filing 13B to waive 6-month period is totally different from filing application under 14 to waive 1 year before marriage to file divorce petitions. unless and until you explain the court that there are circumstances which is an exceptional depravity that you have to satisfy, and if you go through the entire judgment, that may help you. Best wishes.